Welcome to the deep dive. Today, we're starting with something truly startling, a real anomaly in the justice system.
It really is. You have a tragic situation, a fatal HGV collision on the M62. Two people lose their lives.
Yeah, absolutely tragic. And the driver involved, he steps up, pleads guilty to causing death by dangerous driving, gets 6 years.
Which, is a significant sentence. It reflects that responsibility, the direct actions taken.
But that's just part of the story, because then you have Mike, the owner of the haulage company, same incident.
Right.
He gets convicted of gross negligence, manslaughter,
Right.
and his sentence, 15 years.
15. Compared to the driver's 6. That disparity just jumps out at you immediately, doesn't it?
It absolutely does. And Mike's perspective, which is what we're digging into today, is that the authorities, well, they wanted more than just 6 years for this tragedy.
He believes they were looking for a heavier conviction, and that somehow the focus shifted squarely onto him, the owner.
So our mission here is to unpack Mike's account. His claims about why he feels his conviction was, in his words, wrongful and unjust.
We'll be focusing on his specific allegations, claims of police misconduct, evidence being suppressed, and some really confusing aspects about his own legal defense.
And look, if you've ever felt like you're up against a huge system or just wondered how one event can lead to such wildly different outcomes for different people,
Then this deep dive really highlights those struggles, those hurdles in trying to navigate information institutions and the search for what feels like justice.
so let's look closer at that sentence disparity. 6 years for the driver who pleads guilty early.
Which normally clarifies the immediate cause, right?
Yeah.
The person driving admits their actions caused the deaths.
Exactly. But Mike's view is that once that guilty plea came in, the focus shifted. It became about finding corporate negligence, finding fault with the company.
And that's a different charge altogether. Gross negligence manslaughter aimed at the owner clearly carries a much heavier sentence.
And Mike alleges the whole investigation, the trial that followed, it became what he calls a route to convict him.
He talks about alleged wrongdoings by the police. And he specifically calls out the DDSA, the Driver and Vehicle Standards Agency, claiming their input was manipulated. Lies and just manipulated testimony, I think, were his words.
Which brings us to probably the most serious claim, suppressed evidence. Something Mike says could have completely changed the outcome.
This is the missing insurance statement he talks about. It's quite specific.
Tell us about that.
According to Mike, the driver involved gave a separate statement to the insurance company after the crash.
Okay.
And in that statement, Mike claims the driver admitted the accident was down to his actions. Specifically, that he accidentally knocked the handbrake on while leaning over the dashboard.
Wow. Okay, so an operational error, not a vehicle fault.
Precisely. And Mike insists this statement, this admission, was never disclosed during his trial. It wasn't in the evidence files of DCS that he was given access to.
If that's true. I mean, that potentially shifts the blame entirely, doesn't it? From faulty brakes or maintenance, the negligence claim to a driver's mistake.
It goes right to the heart of causation. Mike believes that statement basically proves my innocence regarding the negligence charge. It points directly to the driver's action as the cause.
And he also claims trying to get hold of this statement for his appeal has been incredibly difficult.
Yeah, he says the CCRC, the Criminal Cases Review Commission, the body that looks into miscarriages of justice, he feels they just don't want to do the legwork to get it.
Even though the insurance brokers apparently confirmed it exists and is accessible.
That's his claim.
Yeah.
And he adds context. He points out the insurance company never came after him for the huge costs associated with the crash cleanup.
Which they probably would have done if they thought company negligence, like faulty equipment, was the proven cause.
You'd certainly expect them to try and recoup costs if negligence was established. Mike argues their lack of action suggests they, too, accepted the driver's account of operational error.
Okay, this leads perfectly into the second major evidence issue Mike raises. The whole question around the vehicle's brakes.
Right, because the prosecution's case for gross negligence seems to have relied heavily on the idea of faulty brakes, implying poor maintenance by Mike's company.
But Mike alleges that the police forensic work on those brakes was fundamentally flawed. This is information, he says, only came out after his trial.
His core claim is staggering. He says the police never actually did the proper pneumatic testing on the brake system.
Pneumatic testing. That sounds important for an HGV.
Absolutely essential.
Yeah.
It tests if the air brake system and its components, like valves, work correctly under pressure. Without it, Mike argues, you can't definitively say a component was faulty in operation.
So how did they conclude the brakes were faulty then?
While Mike managed to get hold of a 29-minute video from the police lab, he describes it as showing the brake valve being brutally stripped down.
Stripped down but not tested functionally first.
That's the allegation. That conclusions about mechanical faults were reached based on taking it apart, not on testing if it actually failed under operating conditions.
And he got someone else to look at this.
Yes, he says a forensic engineer reviewed this evidence later and was, quote, absolutely shell-shocked.
Shell-shocked why?
Because, according to Mike, the engineer concluded there was no proof the valve was ever faulty. The necessary tests just weren't done.
So the very foundation of the negligence claimed the faulty brakes might rest on questionable or perhaps incomplete forensic work.
That's the crux of his appeal on this point. If the evidence underpinning that central claim is unsound, the conviction itself becomes highly questionable. And crucially, this analysis came after the conviction.
Let's shift focus slightly to the crash itself, Mike's understanding of it, and the decisions made during his trial. He expresses a lot of regret here.
He does. His description of the driver's actions leading up to the crash is consistent. Speeding, using a phone, and illegal overtake.
And then the key moment.
Leaning against the dash, accidentally hitting the HGV's handbrake lever, which, as you can imagine, would cause an immediate jackknife.
And there's evidence for this specific action.
Mike confirms the truck's own dash cam captured the audible sound of the handbrake being applied. Clear audio evidence, he says.
Okay, that sounds like critical evidence to support the driver error explanation. So why wasn't it central to his defense?
This is where Mike admits his own, as he puts it, naivety about the criminal justice system. He claims his own defense lawyer pressured him over a long period.
Pressured him how?
Persuaded him not to challenge the prosecution's narrative, the faulty brake narrative, and critically advised him not to give evidence himself about the handbrake incident.
His own lawyer told him not to testify about the handbrake sound caught on dashcam.
That's what Mike alleges. It suggests a major breakdown in trust, or at least a fundamental disagreement on strategy.
Why would a defense lawyer advise against using seemingly crucial exculpatory evidence?
It's hard to say without hearing their side. Maybe they feared cross-examination, thought it was too risky, or perhaps, as Mike seems to imply, there was some other reason, a lack of fight, or worse.
He felt his own team wasn't fighting for the explanation he believed was true.
He certainly paints a picture of deep mistrust. He even recounts an incident where his solicitor told him phones weren't allowed when viewing the dashcam footage.
Okay.
But Mike was so worried this key audio evidence, the handbrake sound, would be buried or ignored. He says he secretly recorded clips of it off the screen with his own phone.
He recorded his own evidence because he didn't trust his lawyers to use it.
That's his account. It shows how desperate he felt to preserve what he saw as the proof of what really happened, because he felt his defense team was steering him away from challenging the prosecution's story.
That is quite extraordinary. Looking back, what does he say now?
He says if he could change one thing, he would have definitely stood up and given evidence to the jury about the handbrake. He believes the outcome could have been different.
So the appeal rests not just on alleged police and forensic failures, but also on the claim that his own defense failed to present key evidence.
Correct. It's a multi-pronged challenge to the conviction, addressing issues with the investigation, the evidence, and the legal representation he received.
So where does that leave Mike now? What's the goal?
The goal is clear. Get the conviction overturned immediately. He argues the case against him lacked solid proof of negligence and, crucially, ignored or suppressed evidence pointing to driver action as the cause.
He mentions the impact on his family, too.
Yes, he talks about the suffering his children and family have endured, saying they have to be strong while he continues this fight. For him, justice isn't just about clearing his name, it's for them too.
And what does that justice look like specifically?
It means the official record acknowledging that the driver's action with the handbrake caused the crash, not company negligence based on what he claims is unreliable forensic evidence. He says he won't stop fighting until that's recognized.
And based on this whole experience, he offers some pretty strong advice for others who might find themselves in a similar situation.
Very strong, yes. It definitely reflects the trauma and mistrust he feels towards the system.
What's the advice?
He warns that you absolutely need to find a barrister who is genuinely willing to fight tooth and nail for you, and pointedly, one who isn't part of a network of friends with the police or prosecution involved in your case.
That feeling of the system being potentially stacked against you, or at least too interconnected.
It really encapsulates his experience. So to recap, we've touched on this huge sentence disparity, the alleged suppression of that crucial insurance statement, serious questions about the police's forensic brake testing, and the complex role of Mike's own defense regarding the handbrake audio.
Mike's core belief is that he was targeted, essentially used as a route to convict, to secure a much longer sentence than the driver received for this terrible tragedy.
And it leaves us with a pretty stark question, doesn't it? If evidence, potentially confirmed by third parties like insurers or independent engineers, can allegedly be sidelined or suppressed in such high-stakes cases.
What does that mean for transparency? For accountability within the justice system itself? What needs to change to make sure everyone gets a truly fair hearing based on all the available facts?
Something definitely for you to think about, to mull over, as you consider how proof, justice, and accountability function, or sometimes maybe don't function, within our legal structures.
Thank you for joining us for this deep dive.